Langston,
I'm here, Judge.
Desmond Harper. What are we doing? One case?
I'm working with him, Judge. I'm working. That's a relatively new one. I just did an announcement just 4 weeks, but I got 2 pleas out there.
The announcement in 4 weeks?
Yeah, and the next 2 are pleas.
Anthony Patton.
I sent that to you,
I need Anthony Patton out, please.
and I sent the other one to you too.
Thank you. On Patrick Smith.
That
Or-
plea. Now the other case, can I?
Christopher Watson, right, was the,
Yeah, but that's, Sonny, can you come up with me on that one?
Yeah.
Just please, can you hit your button?
what's 6-3 is called. You are Anthony Patton?
Yes, sir.
Present.
Yeah.
Mr. Adams, your attorney and the state attorney does. The defendant, we have a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about May 11th, 2022 in Jefferson County, Texas, you committed the state jail felony of illegal possession of methamphetamine, controlled substance. Do you understand what you're charged with?
Yes.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
An agreement's been reached here. You would be pleading guilty, sentenced to 180 days in the state jail. You'll be given credit for all time served. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty? You're pleading guilty voluntarily and because you are guilty.
Yeah.
I'm going to show you what's marked here, State's Exhibit 1. Did you sign that document
Yes, he did.
voluntarily, understand it,
Yes.
discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tender, without objection,
Yes, sir.
admitted. This state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial, rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is late.
Yes, sir.
I'm going to follow this agreement. If nothing further, you pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. You are hereby sentenced in accordance with this agreement to confinement in the state jail for 180 days. How much time do you have? Do you know how much time credit you have?
I've been in Jefferson County on this since October, but my time's been growing since October.
He's got, you may be out pretty quick.
He's got another case.
Right.
Anything else? That is all. Thank you, sir.
Good luck, man.
Next, Patrick Smith.
He's done. Mr. Smith.
What?
No, no, you're not.
We hired you back.
What do we do with Patrick Smith?
That's just, he needs to be, he's done. Like, he just got to
Yeah, he just needs to fingerprint.
Fingerprint. He's been doing that all weekend long. He's gonna flip flop and back to those Patrick's, yeah. And one, I don't like the fish on the one thing.
Mr. Smith, please see that lady real quick, and then we'll do this plea. Thank you.
Mr. Smith, right, please raise your right hand and swear or affirm to your own truth or the truth that be God. Okay, please think of your right thumbprint. Right thumb. Yes, sir. Okay, place it flat right there. Okay, you get up one more time. Same time.
These five.
Yes.
Cause number 5CR208, the state of Texas versus Patrick Smith. That's you, sir? With Mr. Adams, your attorney, correct? All right. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed to summary? Yes.
Oh, yes.
In summary, paragraph 1 alleges on or about May 15th, 2024 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more prior DWIs, operating motor vehicles in public places while intoxicated. In 91, out of the County Court of Law of Walker County, Texas, you were convicted of DWI. 91, also the same County Court of Law in Walker County, Texas, convicted. 2001, County Court of Law of Walker County, and March 11th, 2020. Another conviction of a DWI, 4 DWIs. Paragraphs 1 and 2 constitute a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand? An agreement's been reached where you would be sentenced to 7 years in prison, given credit for all time served. Is that your understanding of the plan? Yes. If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to paragraphs 1 and 2, guilty or not guilty? Yeah. Are you pleading guilty voluntarily and because you are guilty? Yeah. And paragraph 2, which of those 4 prior convictions of DWIs out of Walker County, are those all true and correct as they are alleged? And are you pleading true and correct to that voluntarily because it is true? I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered and dead?
No, sir.
Without objection admitted. Among other things, the states you were mentally competent to do this. You were entering your pleas of guilty and pleas of true voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination, totally satisfied with the representation provided by your lawyer. All pleas shall have been. State's Exhibit 1, part of the record without objection. Pre-sentence report is waived.
Oh, yes, sir.
I'm going to follow this agreement and find, sir, you were pleading guilty in paragraph 1 to DWI and driving while intoxicated, operating a motor vehicle in a public place while intoxicated, and pleading true to paragraph 2, which alleges those prior 4 DWI convictions out of Walker County. You were doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting this to find you guilty beyond a reasonable doubt from State's Exhibit 1. I now find you guilty beyond a reasonable doubt of this third-degree felony in paragraphs 1 and 2. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years. Do you understand what has happened today, sir? Good luck to you, sir. Thank you. Here, thanks.
Yes, sir.
Okay, Christopher Watson, please. What are we gonna do on Mr. Watson here?
He had signed up last time we were here, but
What was the date?
we came forth on Watson last 3/31/25.
Never come today on Watson.
Did you have something today?
Yeah.
Yeah, I had something today, which I think it was something that we had signed previously. So I said,
That was for the 18-month state jail. That's what we signed up last time when we were here.
I need him to swear in front of me if he's gonna plead.
Are you gonna be pleading guilty today, sir? And this is 100, no, it's not 18 months. It's
Yeah.
180 days.
it shows 180 days, I think.
That's just 6 months.
What is?
Whatever it was they signed up for last time is what I
How
signed
much
today.
time does he have credit?
Yeah.
He's gotta have that kind of credit.
Yeah.
He's ready to go.
You can get out of jail today.
You won't get out today, thank you, but get out in a few business days.
How much time does he have credit for? Do you know?
2 years.
2 years.
2 years.
He got,
He's getting closer.
last time we checked, I think he was
was-
approximately 85 days, something like that. But he has more than enough time on 180 days to get done.
6 days.
Yeah,
586 days. Is that right, sir?
I don't know.
But I mean, that sounds about right.
It's a long time.
It's a long time. I mean,
Hey, I'm ready. to be-
Are you- okay, this says you're gonna be pleading guilty, sentenced to 180 days, which means you'd be getting out. Is that what you're gonna do? Is that your plan?
No, you told me, you said that I had to be guilty.
Well, you're gonna be, you have to be found guilty. You don't have to plead guilty. You can plead no contest if you want.
I already pled no contest.
No, that's not the way I do things here. I've done this for 19 years. If you plead no contest,
Well,
that's
look,
fine,
if I-
but you have to, hold on.
Yeah,
Sometimes people
at
plead
the
no
2 year
contest.
mark, will you release? Will you let me out of jail?
You get credit. I can't do that. I can't do that, but you're credited. There's no reason for you to be staying in jail in
Yeah, can I
another
go?
moment.
Can I
It-
go? Because you offered me
I-
time served last time I
So
was
once
here.
again, sir, I can't do that. The people make the deal and then I approve it. Then I send it you, then it goes through the processing. And if you've completed your time, you leave. I don't keep you in.
No, he's asking if his case is still pending at 2 years, what happens to him?
Well, it's a state jail felony. If you don't take the deal, we gotta set it for trial and it'll be put on the trial docket. But my trial docket today was 3 pages long. It just gets set with everything else. I can only try one at a time. I've tried 600 jury trials. I can only try one at a time. You don't have to plead guilty. You can plead no contest.
No, you told me that I was guilty and that I had to
You
be.
have to be found guilty and no contest has to be supported by independent proof. And then I make a finding of guilt. Yeah.
Well, what do you suppose now? What are you changing to?
Anything else you want to say? I'm not changing anything, sir. Do you want to plead or not today?
This is communicating. We're communicating.
All right, it's set for trial.
Today.
It's set for trial. That's all.
When-
That's all.
When people come.
We're set for trial. It's set for trial. If you're not going to plead guilty, it's not a debate and it's not a time to grandstand, sir.
This is your fault.
Golly.
I told you.
It's only-
It's only about the 10th time this is falling apart.
It's a political thing or something. All right, who's next?
Uh,
This that's set for trial.
Yes.
Keith DeJean, come on up. 23-313. Weird.
He's got 2 cases.
I understand that. I still didn't understand that one. That's okay. Some people, I guess, love to be in the jail. But I don't understand. It's like whatever it takes for me to stay in jail, that's what I'll do, which is odd. All I can do is now set it for trial. When
I don't understand each other. I don't understand.
Thank you.
2 files. So
I got 2 files, 2 motions to revoke probation.
yes.
Is it one deal?
Yes.
One.
It's
I'm working.
one deal.
What part, sir? Are you Keith Patrick DeJean or DeJean? We call 23 CR 313 and 314. There are 2 motions to revoke probation. You were here with your attorney, Mr. Dusler. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes, sir.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
In summary, we'll take these together if we can. In summary, these motions similarly allege that on July 25th, 2023, you were sentenced to 2 years in the state jail, probated for 5 years in this court for thefts of property. Is that true?
Yes, sir. Whatever counts you on.
Okay. Okay. Number 1, in each case states you failed to report to your scheduled administrative hearing on October 10th, 2023 in violation of your probation order. Is that true?
Yes, sir.
And number 2 states you failed to never become intoxicated or being under the influence of any intoxicating substance, and that on October 19th, 2023, you tested positive for methamphetamine, which was in your system. Is that true?
Yes, sir.
Are you pleading true to allegations 1 and 2 of these motions to revoke probation, which are identical, voluntarily, knowingly, intelligently, and because they are true?
Sir.
You understand by a knowing and voluntary plea of true to 1 or more violations of probation, that's enough to grant these motions to revoke probation beyond a reasonable doubt or by a preponderance of the evidence or greater. Probation now be revoked. You can be sentenced no less than 180 days up to 2 years in the state jail. Knowing that, you insist on pleading truth. I find you pleading truth voluntarily. You understand and appreciate the consequences of pleading truth. In each case, agreements have been reached where your probation would be revoked based upon your voluntarily knowingly made pleas of truth. And you would be sentenced to 1 year in the state jail. Is that your understanding? If I follow these agreements, you have no right of appeal of your case, and then you would be, this would run concurrently. This says restitution paid in court. What does that mean?
We paid in full.
Oh, that's been done. Okay.
So all in favor.
If I follow these agreements, sir, you have no right of appeal. I tend to do this, okay?
Yes, sir.
I'm gonna show you what's marked as State's Exhibit 1. Did you sign that document voluntarily in each case? Understand it, discuss it with your attorney or the contents attorney? Right. State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states that you understand fully that you are giving up all rights of appeal. If I follow these agreements, I intend to do that. If nothing further, I'm going to find that in each of these cases, you have pleaded true to allegations 1 and 2 voluntarily, knowingly, intelligently in each of these motions to revoke probation. That is enough to grant these motions to revoke probation beyond by a preponderance of the evidence or greater. Thus, these motions are hereby granted and your probation is hereby revoked in each of these cases. I am following these agreements and you are hereby sentenced to confinement in the state jail for 1 year in each of these cases to run concurrently. Anything else?
No, sir.
Good luck, sir. Thank you. Okay.
Thank you, Judge.
Yes, thank you. Edwin Dixon.